on hand, we are concerned with criminal liability on account of dishonor of a check. It primarily falls on the drawer. If it is a company, then the drawer company and is extended to the officers of the company. The normal rule in the cases involve criminal liability is against vicarious liability. To put it clear, no one is to be held criminally liable for an act of another. This normal rule is, however, subject to exception on account of specific provision being made in statutes extending liability to others. For example, Section 141 of the NI Act is an instance of specific provision that in case an offence under Section 138 is committed by a company, the criminal liability for dishonor of check will extend to the officers of the company. As a matter of fact, Section 141 contains conditions which have to be satisfied before the liability can be extended. In as much as the provision creates a criminal liability, the conditions have to be strictly complied with. In other words, the persons who had nothing to do with the matter need not be roped in. A company being a juristic person, all its deeds and functions are the result of act of others. Therefore, the officers of a company who are responsible for the acts done in the name of the company are sought to be made personally liable for the acts which result in criminal action being taken against the company. In other words, it makes every person who at the time the offence was committed was in charge and responsible for the conduct of the business of the company as well as the company liable for offence. It is true that proviso to subsection 1 of section 141 enables certain provisions to prove that the offence was committed without their knowledge or they had exercised all due diligence to prevent commission of the offence. The liability under 141 of the NI Act is sought to be fastened vicariously on a person connected with the company, the principal accused being the company itself. It is a departure from the rule in criminal law against vicarious liability. It is not in dispute that the first respondent has not filed any complaint under the provisions of penal code and therefore the argument pertaining to the intention is completely misconceived. Well, as that para is not important, then para 24. In Geeta Berry versus Genesis Education Foundation, the petitioner therein was wife and she filed a petition under 482 of the code seeking quashing of the complaint filed under 138 of the Negotiable Instrument Act. The case of the petitioner therein was that the offence under 138 of the Act cannot be said to have been made out against her only on the ground that she was joint account holder along with her husband. It was pointed out that she has neither drawn nor issued the check in question and therefore according to her the complaint against her was not maintainable. The learned single judge of the High Court of Delhi, after noting that the complaint was only under 138 and not under 420 and pointing out that nothing was elicited from the complaint to the effect that the petitioner was responsible for the check in question, quashed the proceedings insofar as the petitioner therein. In Bandeep Kaur versus Avneet Singh, in a similar situation, the learned judge of the Punjab and Haryana High Court held that in case the drawer of a check fails to make the payment on receipt of a notice, then the provisions of section 138 would be attracted against him only. The learned single judge further held that though the check was drawn to a joint bank account which is to be operated by anyone, the petitioner or by her husband, but the controversial document is the check, the liability regarding dishonoring of which can be fastened on the drawer of it. After saying so, learned single judge accepted the plea of the petitioner and quashed the proceedings insofar as it relates to her and permitted the complainant to proceed further insofar as against others. In the light of the principles as discussed in the earlier paragraphs, we fully endorse the view expressed by the learned judges of Madras, Delhi and Punjab and Haryana High Courts. In the light of the above discussions, we hold that under section 138, it is only the drawer of the check who can be prosecuted. In the case on hand, admittedly, the appellant is not a drawer of the check and she has not signed the same. A copy of the check was brought to our notice. Though it contains the name of the appellant and her husband, the fact remains that her husband alone had put his signature. In addition to the same, a bare reading of the complaint is also the affidavit of examination, chief of complaint, and a bare look at the check will show that the appellant has not signed the check. We also hold that under section 138 of the NI Act, in case of issuance of check from joint accounts, a joint account holder cannot be prosecuted unless the check has been signed by each and every person who is a joint account holder. The said principle is an exception to section 141 of the NI Act, which would have no application in the case at hand. The proceedings filed under 138 cannot be used as an arm twisting tactic to recover the amount allegedly due from the appellant. It cannot be said that the complainant has no remedy against the appellant, but certainly not under section 138. The culpability attached to the dishonor of check can in no case, except in case of section 141 of the NI Act, be extended to those on whose behalf the check is issued. This code reiterates that it is only the drawer of the check who can be made an accused in any proceeding under section 130 of the Act. Even the High Court has specifically recorded the stand of the appellant that she was not the signatory of the check, but rejected the contention that the amount was not due and payable by her solely on the ground that the trial is in progress. It is to be noted that only after issuance of process, a person can approach the High Court seeking quashing of the same on various grounds available to him. Accordingly, the High Court was clearly wrong in holding that the prayer of the appellant cannot even be considered. Further, the High Court itself has directed the magistrate to carry out the process process of admission or denial of documents. In such circumstances, it cannot be concluded the trial is at an advanced stage. Under these circumstances, the appeal deserves to be allowed and process pending is quashed. Hence, my lords,
They had executed any documents.
any agreement or such? No, my lords. Not to my knowledge.
Only check was issued by the.
Only check was issued.
Yes.
Please. Yeah, my lord. Whatever my lord.